Hi, good afternoon, everyone. This is Rajiv S. Khanna for immigration.com, the law offices of Rajiv S. Khanna PC. You already know that these calls are being recorded, so be careful with the information you put out. When you log into our conference, there is an announcement that talks about the details of the terms of this call. So be careful with that. That said, my first question is a question that comes up, I wouldn't say frequently, but it does come up quite a lot. Here is the problem. I have an arrest, but I did not disclose that in my immigration papers. Okay. Um, the funny thing is, mere arrest without a conviction has absolutely no immigration consequence. But if you do not disclose it intentionally, you can be barred from entering USA permanently. So any attempt or any receipt of immigration benefit based upon a misrepresentation or fraud is a permanent bar. The problem is even an attempt becomes a permanent bar. Okay, so when you have a situation where there is a misrepresentation in your paperwork, what should you do? It's a very difficult question to answer. In my view, it should be disclosed, and of course it can lead to permanent bar, but you have some argument that you came forward and you corrected the problem as soon as you became aware of your rights and responsibilities. Okay, for you, the person who was our first poster, Ahmed underscore November 1984, I think you should contact us for a one-on-one consultation. You can send me an email to help@immigration.com. Help@immigration.com. I cannot say that I'll be able to help you, but at least I can give you the direction you need to head. Okay, so go ahead and set up a call with us. Like I said, or you can just pick up the phone and call us. Help@immigration.com is my personal email. Okay, let's see how we can guide you and perhaps get you out of this mess. Next question is from just a question. That's the name of the user, our community member from Boston, I guess. Uh, 485 RFE is asking for an employment verification. As you, a lot of you who have 485s going know that the government has been sending out tons of letters in 485 pending cases. And I have a couple of other questions as we go down, I think, on 485. But this one says the discrepancy is that the perm said master's plus 2 years experience with no alternate, but the new employer's job letter says bachelor's plus 7 or master's plus 2. I think you'll be okay. Here is the very odd thing about Department of Labor and USCIS. And I make this comment because it's important for you guys to know it. Masters equals 2 years or masters equals 5 years of experience, depending upon Department of Labor or USCIS. DOL says it's 2 years. USCIS says it's 5 years. So your formula would be okay under USCIS standards. MS plus 2 or bachelor's plus 7. If you took the same formula and went back in time, which you don't have to luckily, you would have a problem with the Department of Labor. They'll say it's excessive. It's not good. So in your case, I think you're going to be fine. You've got 4 questions. Do I have a risk of denial? I do not believe so. I do not have a 4-year bachelor's degree. So what? You've got a 3 plus 3 combo. You've got a 3 plus 3 combo. You've got a 3-year bachelor's and a 3-year master's. And I'm assuming it's an MCA from a university. That's a very common pattern, and that's a pattern government recognizes as equivalent to a US master's degree if you got a 3+3 pattern in the same disciplines and from Indian universities. See, India is a little different, and I'm assuming that you're from India. Um, India is a little different in that in India, if you want to call yourself a university, you have to be chartered by the parliament, as far as I remember. I don't know if the laws have changed. So in other words, if you're a university, if the name university appears in the name of an institution, it is automatically accredited. Is the degree accredited according to US standards? That's a different question. So in your case, 3+3 should be okay. I don't see any problem with that. Of course, I am just making educated guesses. If you want better information, talk to your lawyers or set up a call with us. I want to go over your paperwork. Okay. Question number 2. The letter says, the experience letter says I'm a full-time employee, but it doesn't use the word permanent. Permanent is not a required word in my opinion, because no job in the United States is permanent. There's no such thing as a permanent job. As long as the job does not have an end date in sight, for example, a contract-based job. And again, I make a quick footnote here. In the academic context, even renewable contracts can be considered to be permanent jobs as long as the contracts, for example, for a researcher, are renewed normally indefinitely, and they have the normal expectation that they'll be renewed indefinitely, and if they are based upon grants, the university or the research organization continues to seek grants. I digress, but I just wanted to give you that piece of information. So I don't think the word permanent should be necessary. As long as the job is not temporary, I think it's enough. Question number 3, if there's a risk, can I change job? No, I don't see the need for that. I haven't looked at the rest of your paperwork. For example, I would like to compare the two jobs. Question number 4, I heard that when replying RFE, one need to include the RFE gold sheet on top. However, I did not get any gold sheet. I'm sorry, my friend, I have not personally put together these packages for a long time. I'm more the strategy guy. So you can, in the IT language, you can consider me to be an architect rather than a coder. So I don't really know exactly what the instructions say. Other people in my team would know. But I'll tell you this. If you did not get any particular sheet, and I know what you're talking about in this instance, if you didn't get it, it's not a big deal. As long as your RFE is there, that's all you need. Okay. Your employer's attorney said that it's okay to submit an employment letter without mentioning the educational requirement. I'm uncomfortable with that. I think, and I've seen these RFEs, they specifically ask us for a letter that mentions the educational requirement for the experience. Let me rephrase that, for the job offer. Therefore, if USCIS has specifically asked for it, I think we should supply it. Page 123 says about the H-1B outplacement. You have some question. Look, I did not look at these clauses once they went out of the Senate because I really don't know what the final format is going to be. So I kind of stopped paying attention to it. I wanted to see the general structure, and I did some videos on that. I did a video yesterday. I think you should definitely see that. If you go to immigration.com, right on the very top of the page, there's a link to Immigration Reform 2013. Click on that page and you'll see an entry and links to the videos and the presentation I have made. What is going to happen on July 10th? Again, I don't want to repeat all that information. The bottom line is, until July 10th comes and goes, we will really not know what is probably going to happen in the House. So I've been staying away from looking at the statutes and the bills, not the statute, the bill. But I know that our office is working on preparing a quick write-up on H1s for an Indian news organization. So I think it's going to be done by this Friday. Why don't you send me an email to help@immigration.com, and I'll drop you a copy of that article. Because on Friday I'll have to review it again just to see what the amendments are and where does it stand today. Okay, so Friday I'll give you your answer, which is I guess tomorrow, maximum by Monday. Okay. Zach has it says he used to work for one company that got acquired by second company, and the second company says we are the successors in interest. By the way, successor in interest can have slightly different nuances for green cards and for H1s. But the basic idea is the same. The company comes in, the job doesn't change, they take over your employment and they are responsible for you. That's the basic idea of a successor in interest. But the interesting question is, the company doesn't want to change or file new H1s, which is fine, which is fine. But the interesting question is, what if I want to transfer? Now, I used to work for company A that has been acquired by company B. Okay. Now, when I want to go to C, I'll have approval from company A, H1 approval, pay stubs for part of the time from company B, but I'm applying for transfer through company C. Interesting question, logistically problematic, because I think you will need some information from company B that shows that they are successor in interest. If you go without that, you can make the argument to the government that they told us they are successors in interest. We have no way of knowing it. You can ask for a copy of the successor in interest documentation as well as a copy of the LCA. Most of these companies, they would have either, when they became a successor in interest, they would either redo the LCAs or they would put a memo in the public disclosure file that says we are now successor in interest. Get a copy of that memo. You are entitled to a copy of everything in the public disclosure file. Any member of the public is entitled to it. That way you can establish that they are successors in interest. So when you go to company C, approval from A, pay stubs from A, plus pay stubs from B, plus the documentation from the public disclosure file will make it clear that you are fine. I think you'll be okay with that. Okay. Reply 58T. Visiting India H1B change of status applied. See, the problem is, if you are applying for change of status from any status to any status and you leave, that change of status request is abandoned. Okay. If you travel to India before your H to L or L to H transfer, change of status, you have two choices. When you come back on L1, as long as you're still maintaining L1 status, come back on L1 and then apply for change of status, which is like refiling H1 all over again, except that you're not subject to the quota. Or you have to go get visa stamping. Same thing for your wife, L2 to H1, any status to any status. If you have applied for a change of status, if you travel, it can be a problem. The next question actually is a little different scenario, and I think it's the next question. Yes, it's a little different scenario because the change of status has been approved and then the individual traveled. We had a discussion with USCIS on this a couple of weeks ago, and USCIS confirmed what we believed. The way it works is, so let's say I'm on F1. I've applied for change of status. My F1 continues to October 1st, let's say. Okay. It's not expiring before October. If I travel after the H1B has been approved and come back on F1, USCIS said there is no problem because change of status has been approved. So October 1st, I am automatically on H1. But if I travel before the F1 to H1B is approved and I come back on F1, then I have to apply for change of status or a new visa, just like that L1, L2 situation we talked about. I hope that's clear. That's for Satya.Horizon. Next question is Raghu 2082, AC21 portability advice. He's got an AC21 portability situation, got these questions. One of the things that Raghu found out was that there are different immigration discussion forums that say once AC21 letter is filed, it really does not get included in the green card file. That's not my experience. If you do it well enough in advance, it does get included in your green card file. Okay, so to say that if the I-140 is revoked by the old employer, you'll automatically get a denial of the I-485. That has happened in those cases where for some reason either an AC-21 was not filed or it was filed and USCIS misplaced. That can happen, but very, very, very rarely. It used to happen a lot more in the past. Denial once the I-140 is revoked, because USCIS had not really caught on to an exception of AC-21 that would protect an employee. So they used to issue and I've seen a couple of these denials in the last 30 years, but not more than that. Okay. Of course, AC-21 has been around only for about 13 years. I think, was it 13 years? October 2001? Yeah, I think so. About 12 years. Okay. Second question. I have a master's degree with 8+ years of experience. Perm job requires master's with no experience. New job, bachelor's degree is required, master preferred with 10 years of experience. See, I don't know if this difference is going to create a problem for your case. I think it should be okay, but really it's up to your lawyers to decide how best to handle it. I would have to look at the entire job. I would have to look at the way these jobs are described. You know, I cannot really give you a decision in vacuum. That's the next question. Job title is different. Also, I cannot really give you an opinion until I review the whole set of papers. You said there were some added responsibilities like technical supervision, managerial. See, if you look at the AC-21 statute, it uses the phrase, the jobs have to be same or similar. And I've said this a number of times before. Obviously, similar does not mean same. So that means some amount of variance is okay. You still are entitled to AC-21. But what the details of this variance are, what is permitted as a variation, we don't really know that because we don't have regulations. Okay, so I cannot answer the questions about qualifications, title, variation in job descriptions in a vacuum. It's very specific to each case. My new job is in the same technology, but the title is different. We got that. The next question, you've numbered them both three. I think it's four then. The salary is 30% higher and the job has changed from Michigan to New Jersey. Can this create an issue? Again, very tightly fact-bound question. Very difficult for me to say. I mean, am I allowed to get some yearly raises anyway? I guess so. Why not? 4, 5, 6, 7%, even 10%. So if I filed my labor cert 10 years ago and I got my I-485 filing done now, in 10 years if my salary has doubled, is that a problem? I don't think so. I think that should be okay. But I'm making a guess here. I have to look at the entire case. In the event I receive an RFE on my employment with the original sponsor, I won't be able to get support from my green card employer since I have moved out. That's fine. That's the whole idea of AC-21. You should never have to go back to the old company. 5. In the worst case scenario, if the 45 is denied, can you use the priority date? Absolutely. Even if AC-21 is denied, you can still use the priority date in another green card filing. Are there any other risks one should be aware of in the job shift using AC-21? None that I can think of other than what you have covered. Denial is the biggest risk. Some delay maybe if they decide to interview you, but that's not always true for AC-21 cases. I don't think it is any higher percentage of interviews for AC-21 filed cases than in comparison to non-AC-21 cases. I think it's about the same. Money wants to know, my wife and I received my green card in October 2011. Father passed away. I have to go to India for 2 years to settle my mom. I would probably have to resign my job and take up a job in India. Is re-entry permit always tied to a US based company? No, no. Re-entry permit is not tied to a US based company, but N470 is. So look at N470 also, just to make sure that you understand what you're doing. Um, Under your particular circumstances, I think you'll be fine. Okay. Is this a valid reason for re-entry permit? I think so. I think so. It does not look like an invalid reason to me. Okay. Next question is NECAT. NECAT says, I've submitted my N400. Can I travel outside USA while the naturalization application is pending? So between fingerprinting and interview. I do not think that should be a problem. N400 is one of the exceptions to the rule that you should not travel when an application is pending. I don't see any problem. As long as your travel is, not for 8 months or 10 months or 12 months, because then you have a problem with maintaining your green card. A few weeks, no problem. I don't see any issue with that. Kirtika says, H4 to H1 change of status and H4 extension. I just read this question. I think this is how the situation is for Kirtika. She's on H4. H1 had been applied for. H4 extension is also being applied. So the question is, if the H1 gets approved and then the H4 extension gets approved, what happens? That's a difficult question to answer. There is something called the last action rule. Interesting thing is, nobody knows whether this is a real rule or not. Even USCIS, some of the very senior USCIS lawyers that I've had the occasion to speak with have said, we don't know where this rule comes from. What does last action rule say? If I've got an H1 approved, then an H4 gets approved, I'm on H4 because that was the last action taken in my case. Okay. So that is always problematic. And when you have a gray area, the role of a lawyer is to avoid all gray areas. So you've got to talk to your lawyers. I think one way to handle that would be to withdraw the H4 application immediately once the H1 is approved. Okay. So talk to your lawyer, see what they suggest. Satya KB, EB3 to EB2 interfiling clarification. He's got an EB3 approval, I-140 approved, 485 filed. Then EB2 through employer B. So now the question is, when do we need to submit interfiling request? For those who don't know what that means, I've got an I-140, I-485 tied in onto an EB3. Then I got an EB2 I-140 approved. I want to take my EB2 I-140 and put it on top of my EB3 I-485. That's interfiling. Well, first of all, USCIS, I've said this before and I'm repeating it again for your information. USCIS has been, now it's a settled practice. They conduct sweeps on a monthly basis, maybe more than monthly basis, and they automatically assign to you the earliest priority date to which you are eligible or which you are eligible for. Okay, so they do it automatically. But by way of abundant caution, it does not hurt to send in a letter saying that please note that I've got this I-140 approval and this 485 pending. Kindly attach my EB2 I-140 onto the I-485 that was filed. So that should take care of it. Okay. Again, if you want to follow it up, you can do a customer service call and see if they can do anything for you. But typically, it's done automatically. There is not a whole lot you should have to do. Okay. Reddy wants to know, oh, I'm sorry. Somehow I missed reading this question earlier, so I have to read it. Oh, okay. Yeah, no, I read it. Sorry. So the question was, I haven't had a visa stamp, H1 visa stamp, for almost 6 years. Is there any law that says you cannot stay in USA for these many years with expired visa, although having valid I-94? No problem at all. Reddy, there is nothing in law that prevents you from staying in USA with an expired visa as long as your I-94 and status is active. So that by itself is not a problem. Don't worry. Rakesh wants to know, uh, he's got a degree, MS degree from an accredited university, then an MBA from an unaccredited university. How does he deal with that in an H-1B visa interview or in the paperwork? I would just ignore the degree from the unaccredited university. I see no need to harp upon that. You can let that not be, um, you know, you can just leave it out of the paperwork. Because if it's an unaccredited university or an unaccredited degree, it doesn't really mean anything. You can leave it out. It's like having a, a diploma, for example, in Hadoop. It's not a degree, you don't have to put it down. Okay. Bhaskaran. So, B. Banerjee. Um, I think you also sent me an email through LinkedIn, and I think we talked, but I'll repeat it anyway. Um, to apply for an EB1C, which is executive manager or executive or managerial level employee, sort of L1. To apply under that category, you need to have the employer help you with the paperwork. They've got to provide the letter, they've got to provide the supporting documentation, they've got to sign the I-140. You can pay for it. I don't see any problem with that. Can I simultaneously apply green card for my wife and 10-year-old son? Absolutely. But you cannot do it by yourself. The employer has to sign the paperwork. Question number 16. And this is the last question for the day, great. Then we can take new questions and follow-ups as well. The question is from Jack Collis, who says, look, I've got my green card. My wife's 485 is pending. They sent an RFE saying, show that you've got a valid job, etc., etc. That's nonsense. Don't worry about it. As you know, and you have mentioned, then USCIS sent a letter saying, by the way, if you are a dependent or a derivative beneficiary, you don't need to respond to this RFE. Here's what you should do. This is what our office is doing. What we are doing is, we are responding to the RFE with a copy of that notification from USCIS saying, we are not responding to the RFE because I'm a derivative beneficiary. That way, you have very neatly tied in all the loose ends. So respond to the RFE with a copy of the notice that requires you not to respond. Okay? That should take care of it. Alright guys, I'm done with all the questions that were posted. First, I want to take on any follow-up questions. By the way, before I forget, do go to immigration.com, click on the very top, you'll see, I can actually show you on the video. You will see, let's see if I can get you there. At the very top, you see this comprehensive immigration reform. Click on that. I want you to click on that. And this 4th of July entry, which I have made, this is about a video and some presentation slides about what is happening with the immigration reform in the House. Please review this information. It's, I think, important for everybody to know so you can follow the process of what's going on. And share it with other people as well. Okay, anybody who has a follow-up question on what we have discussed, press *5. No new question, only follow-ups. Once you've done that, then we'll get to new questions. Okay. 1, press *5. I have one question. Oh, good. Then we can take all new questions after that. Okay, California, go ahead, please. California.
Hello, sir. This is Satya KV.
Yes, sir. Hello.
Thanks a lot for all your support.
My pleasure.
This question is regarding the same interfiling from EB3 to EB2.
Sure.
So when do we send the letter? Is it like after the priority date becomes current or before?
I would like to send it now and then send it again in the month before the priority date becomes current.
Okay, so
Okay.
it's better to send both of
Yeah,
them.
it's really not required, but if you feel uncomfortable, just do it anyway.
Okay.
It-
And would that be the final step, or like, do we really need to do anything else after it becomes current?
If you want to be, I guess, more comfortable, you can even call the month your priority date becomes current, call USCIS customer service.
Oh, and then like talk to them about the status.
Exactly.
Okay, sir.
All right?
Okay, and those will be sufficient enough to take care of the situation.
Absolutely. I think it's an overkill, but that's all right. If you feel more comfortable, do it.
Okay.
All right.
Thanks a lot, sir.
You're welcome. Okay, guys, any question at all? Press *5. Any question? One question, two questions, three questions, four questions. Okay, I'm going to take it in the order in which you guys logged into the conference call. Okay, so Hartford, Connecticut. Go ahead, please.
Hi, Rajiv. Good morning. Happy Independence Day.
And you too, sir. Thank you.
This is regarding to my I-140. So we filed I-140 in a regular process 4 months back, and I got a subsequent RFE. So requesting for an educational evaluation.
Okay.
We submitted the RFE educational evaluation nearly 70 days back. But we haven't heard anything from them. So we already passed the four months of SLA and 2 months of RFP response. If we go to the website and the case status, we passed the date from the responded RFP to the 60 days time. And so my attorney, so they tried to open a ticket, e-ticket, and but the system says the case is still within the SLA. So we are not getting any response. Do you suggest anything in this situation?
There's always the possibility of just calling them. Okay. USCIS online services are still full of glitches and bugs. So why not just call them up and ask the customer service to take care of it for you?
Okay.
All right. Good luck.
Thank you.
You're welcome. Okay. Is it Camarillo, California? Go ahead, please.
Yes, Rajiv, this is Dixie calling from Camarillo.
Yes, sir.
Yeah, so my question is regarding it's a successor in interest, or there's some concept of an I-140. Now, the thing is that, the question is the successor interest amendment I-140, sometimes some says that it's not necessary to be filed based on the merger, or some says no, it has to be filed. But there is certainly it seems that there is no a very rule which needs to be filed. And
No, hang on. Let me stop you for a second.
Hello?
Let me stop you for a second. You said, can you hear me?
Yes.
Okay, good. Let me stop you for a second. I want to tell you something. There is a rule. When, in the H1 context, if there is a succession, you don't have to file a new H1B. But in the I-140 context, you have to file a new I-140 when there is a successor in interest.
Okay.
It's required. There is a USCIS memo, and it should be a part of the USCIS standard operating procedures that do require you to file an amendment.
Okay. Now, but in some cases, where the merger is a direct merger, a merger among the subsidiaries, And then there is so it's like as per some of my friends also in the same their lawyer said they have informed UCIS and they have filed the I-145. So what is the like risk in this case? Like it has been already filed 180 days. And what is the way out if it has not been filed, or is there any way out, or something needs to be done?
Let me take that question step by step. So, first question was if in the I-140 context there is a, um, you may want to put yourself on mute. Your line has a lot of interruptions. Put yourself on mute.
Okay.
Okay, now listen. So, let me take this question step by step, dissect it. First of all, situation in which a company gets taken over by another company. I-140 was approved by the earlier company, and this is a successor in interest. Do we or do we not have to file I-140 again? The answer is we do have to file I-140 again. This has been clearly stated by USCIS. If somebody tells you law is not clear, no, they are wrong. Law is clear. Policy is clear. Okay. Second issue, what if the merger is within the same conglomerate or same set of companies? I think you still have to do a new I-140. Third issue, what if it is within the same set of companies and 180 days have passed after 485 filing? That becomes more tricky. I think an argument can be made in those cases we do not have to file an I-140. We can take advantage of AC-21. Okay, and I think that's a good argument, and I think that should be okay. So if AC-21 is applicable, you may not have to file a new I-140. Okay, go ahead with your questions if you have any follow-ups. Go ahead if you have a follow-up. Yeah.
Okay.
Are you all set?
Yeah.
Okay, good talking to you. Bye-bye. Okay, let's go on to Texas. Go ahead, Texas.
Hello, yeah. I have a question. I'm about to start my 7th year on H-1B visa,
Yes.
and the lawyer went ahead and applied for an extension, but he told me that the problem he foresees is the anniversary for my term, the labor certification, and the expiration of my H-1B, they did not match. So I am 30 days gets short.
Okay.
Are you familiar with my situation?
Of course. I know exactly what you're talking about. Okay, so your question is what do I do?
Yes, I mean my question is, do you think I'm going to have a problem with the extension for the extension for the visa? Will I be denied? Is that a problem?
Okay, this is what I understand your situation to be. Your situation is your perm was filed a few months ago and your H1 extension will be filed for the 7th year. But there's a 30-day gap between 12 months of perm and the start of the second H1. There's a 30-day gap, correct? Okay.
Exactly. Yeah.
So your question is, how will USCIS handle this? Will they just give me an H1 with a new I-94, or will they ask me to go outside for visa stamping? They'll probably ask you to go outside for visa stamping, and you'll be required to stay outside USA for those 30 days. Okay. A couple of little things here. You can actually come back in 10 days before the start date of the new H1 with the new H1 visa stamping. So technically you have to stay outside for 20 days. Okay. Do you have any time to recapture? Have you been outside USA in the last 6 years on H1 at all?
Yeah, unfortunately, he asked me that, and I didn't have days that he can recapture.
Okay, if you don't have recapture, then there's going to be about a 20-day period. Likely scenario is you'll have to go outside USA for about 20 days.
Okay. Now, he went ahead and advised me to go ahead and switch status to F1. Do you think that was a good advice for me to follow?
Only if you genuinely want to study. Okay, because to me it's always troublesome when people just want to convert to F1 as a gap arrangement. I usually don't recommend that.
Yeah.
Okay.
Okay. Thank you very much.
Oh, you're welcome. Good luck, sir.
Mhm.
Okay, the last question for today is from Georgia. Georgia, go ahead, please.
Hi, I emailed you. I have kind of a unique situation. I'm calling on behalf of someone else. But I have a friend who's in India right now who is trying to bring over an unaccompanied minor. He's an orphan, and his parents will not be
Oh,
with him on the
yes,
trip.
yes, yes.
And I was just wondering,
I remember your email. You are a volunteer.
yes,
You are a volunteer. Okay, okay, let's look at this situation. So, your friend wants to bring a minor who is an orphan. Okay, keep going.
yes, he has a father, but his father does not take care of him. He lives in an orphanage. And so on the U.S. side of things, it's easy to look at their websites and see what kind of consent letters we need. But I was wondering if you knew anything about when they were trying to leave India, what kind of letters or consent that they would need to bring him.
So, your question is this. From the American side, you are clear what you need to get the child into USA. Is that what you just said?
Yes,
But you're not sure what the child would need to depart India. So, in other words, what is the Indian law on this issue, right?
correct.
Okay. Well, you know what? I am sorry, but I don't practice Indian law. I thought your question had to do with American law, and I would have tried to help you from that side.
Yeah, if you can help with that also, because the only information I have is from the U.S. Customs and Border Protection website.
That's all you need.
And I'm sure it's not
No. That's all you need. Actually, CBP, personally, in my opinion, have done an exceptionally good job with their website. And remember also, if you take a printout, government website information has the force of law. Whatever they say, they are bound by it.
Okay.
Okay, so don't worry. If you've got the CBP information, that's all you need. That's where I was going to send you anyway. Okay. Now the question is, what do we do from the Indian side? Let me think about this for a minute. I think a good place to start would be to talk with a travel agent in India. Okay.
Okay.
Because there are two aspects of this. Travel agents usually should know both. One is boarding the flight, because under some international regulations, flights have to check certain documents. Airlines have to check certain documents before they allow a person to board the flight. And the second would be when they leave India, they have to go through some immigration clearance on the Indian side. Travel agents usually know both sides. What does it take to board the flight? What does it take to clear immigration? Feel free to send me an email. I'll be happy to help you out. You're welcome to just from time to time, if you run into any issues, this is a good cause. I'll be happy to volunteer my time and whatever I can do for you. Okay?
Thank you so much. Yeah, this is all very helpful. Thank you.
Anytime. And you have my email. It's help@immigration.com.
Okay, yes.
Okay? Good luck.
Thank you.
You're welcome. Bye-bye. Okay, I guess one more question came up, then went away. All right, folks, 1 second. I'm a little confused now because I saw hand flash and then it went down. Let me put everybody's hand down. 1 second. I don't want to leave anybody out. Okay. Now, I put down everybody's hands that had been raised. So if you have any question left over, new, old, press *5 on your phone. *5. Any question left? Oh, wow. 3 more? Huh. I thought we were done. Okay, let's try again. Oh no, these are new questions, I see. Okay, no problem. We'll do it. Again, I'm going in the order in which you logged in. Northern California. California.
Hi, Mr. Khanna. Thanks for answering my question on the re-entry permit.
Sure.
As a follow-up, my question is, do my wife and I have to apply together? Because I have started to look for a job, but I don't know when I'll get. So can we use the same reason, the personal reason, and so that my wife can go ahead and settle
I
down
don't see
and then whenever.
I don't see any problem with that. You can apply separately, and you can use the same reason.
Okay.
Okay. Good luck.
All right. Thank you.
You're welcome.
Thank you.
You're welcome. New Jersey. New Jersey, Cliffside, New Jersey. Go ahead, please.
Hi, Raju. Good afternoon. Currently, I'm on F1 visa, and my OPT extension has been denied, saying that I was unemployed more than 90 days. But my offer letter from my employer says that I was employed with my employer, but I haven't provided the timesheets to USCIS for my RFE. But if I file an NTR and if I could able to submit the timesheet, would they reconsider my case?
Yes.
With the
Yes.
form?
Yes, they should. But you should also add some detail about why you could not provide this information the first time around. So not only should you provide the information covering that point, you should also give an explanation why you could not provide it the first time. Okay. Now let me tell you something interesting. When you are an OPT, there is no requirement that you must have full-time job or you must have a paid job. You can have, I think it's 25 hours or 20 hours is enough, and it can be an unpaid employment. It can be a volunteer job. You could be working for a professor writing a paper. Okay, so just keep these two things in mind.
Okay.
All right.
Yeah, and by like how many days I can stay in USA after my OPT extension, OPT denial?
Technically, you can't stay in USA at all. Okay, and that's
I can't?
that's something I would want to look at your denial. Email that to me and put in your cell phone number in there. Do it today so I'll remember your case. I'll give you a call back tomorrow. And of course, there's no charge for that. I usually don't charge students. Just send me an email. Put me a scanned copy of your denial. I want to see if you are unlawfully present. Okay, I'll explain to you.
Sure. I will do that.
Once I see your denial, I'll tell you what you should do. Okay?
Mm-hmm. Yeah, okay. Thank you.
Good luck. California?
Yes, Rajiv?
Yes, sir.
Yeah, Rajiv, so based on the follow-up, just wanted to now if the AC-21, if the case is already eligible for the AC-21, so then it is fine. Like if the amendment was SSI amendment was not filed or not, that can be a tricky. So if the case is eligible for AC-21, that means it could be good, right?
In my view, yes. But there is a counter opinion possible in this case, because you've got two requirements that are militating against each other. They are fighting against each other. One is a policy that says if there is a successor in interest, you must refile the I-140. The other one is a statute which says if the I-140 was approvable when filed, and then 180 days have passed after the 485, you don't have to do anything. In my view, because one is a statute, which is the AC-21, it trumps policy. Therefore, you should have no problem if you have not filed a new I-140 once you become AC-21 eligible.
Okay.
Okay?
Okay, good. So in any case, like I wanted to further do this, can I send a mail and we could talk a little later, like establish some relationship in case something I wanted to.
So if you want to,
like,
if you want to retain our firm, or if you want an opinion from us, you're welcome to call back for opinions or general advice. Um, you're welcome to call back into these conferences. But if you want me to specifically look at your case or our firm to assist you, send me an email. We'll take care of it for you.
Yeah, Raji, because like I was trying to see like so many cases like like the particular merger case is very different. In case some of the lawyers say that if there is a merger between all the subsidiaries and it has to go for a new income tax number, but in some cases like the subsidiaries are trying to the function as an independent still with their own functionality, but in that case sometimes like amendment does not necessarily might require.
Well, I don't think so. I don't think so. But I just told you what my understanding of the law is. You should be fine with that.
Okay. Thank you.
Okay. You're welcome. All right. I'm a little lost. I think I did Cliffside, New Jersey. I think there's only one left. Caldwell, New Jersey. Go ahead, please.
Hello, Rajiv.
Yeah, go ahead.
Hello, Mr. Rajiv. Can you hear me?
Yes. Call me Rajiv, please. You can skip Mr. You can skip Mr. Khan and just call me Rajiv.
Right. Actually, there's some problem with my phone, and I've been trying to reach you, and I've done it multiple times. I did star fight, and I had to back out again. I couldn't do, so I was not sure if it was recording. But my question to you, Rajiv, is about the AC-21 portability that I saw from you. I know that you've not been able to give me specific advice on my job qualifications, and I understand that based on the fact that you don't have my new job as well as my old firm certification. What is your advice for me now? Do you want me to send an email to info@immigration.com to set up a call with you, or how would you like me to proceed?
It's not info. It's not info. It's not info. It's help@immigration.com. Okay. But wait. Which question? Which question number was yours?
This is mine is the AC-21 portability advice. I have like 6 questions listed in there about general questions about AC-21 and some specific questions related to my specific job description.
Oh yeah, I see you. This is Raghu. Is this Raghu? Is this Raghu?
Yes, this is Raghu.
Okay. Let me take a quick look. Let me see if you need a consultation. Yeah, I will have to look at your paperwork because we are talking about job title being different, some managerial responsibilities, the salary being 30% higher. Send me an email, Raghu, to help@immigration.com. I will have one of my colleagues work with you. They'll prepare the documentation that I need to see, and I'll give you an opinion. Okay?
Okay. Well, I think I sent an email once, but I was sort of
To me?
backed down by. Not to you. I sent an email to the regular. I guess.
Yeah, but all emails should be responded to by the next business day. I'm not sure what's going on, but just send me an email. I'll take care of it.
Okay, so I'm going to do it at help@immigration.com, and I will quote my question number in call so that you'll have a reference to that.
Absolutely, I'll be happy to take care of it for you. No problem at all.
Thanks a lot, Raji.
Oh, you're welcome. Okay, let me put everybody's hands down, and we'll do one last sweep. Okay, guys, last call. If anybody has any questions whatsoever, press *5. Anyone has any questions, press *5. Okay. Oh, there's one question from Leesburg, Virginia. Go ahead, sir. Hello.
Hello.
Yes, go ahead, please.
Yes, sir. This is Nikat. I'm sorry I joined the call late. I had a question about traveling while your 10400 is pending.
Right. I already answered. I already answered that question. I hate to repeat myself, but I'll do it this one time for you. Um,
Really
I
appreciate
I
it.
did answer that traveling for a few weeks is no problem at all. Okay.
Oh, okay.
Yeah.
So there.
If you're traveling for more than 6 months, don't do it without talking with a lawyer. But if you're traveling for just a week, 2 weeks, 3 or 4, even 5 weeks, it's okay, no problem.
Because I heard that it might trigger fingerprinting again. That is not the case.
Uh, that would be kind of silly. Think about it. It. It's not like you're going abroad to change your fingerprints, right? So, no, I don't think any reason for, I don't know of any reason for them to be taking your fingerprints just because you traveled.
Okay.
Okay?
So as long as I'm there for my due date, everything should be fine.
I don't see any
After
problem.
fingerprinting.
All right?
Great. Thank you very much, sir.
You're welcome.
Much
Good luck.
appreciated.
Bye bye.
Okay.
All right, folks, we are done for the day, and I'll talk to you again in 2 weeks. Remember to check out our free apps. We have apps for both the iOS, the Apple platform, as well as the Android platform. I like them. I think those are good apps. Check them out and leave us a comment if you like it, don't like it. All right? Good talking with all of you. Talk with you in a couple of weeks again.